now we're going to move on to the key takeaways. Now, Sean, I know that you had a slide of key takeaways. We're going to offer you the opportunity to review them should you choose to. But I'd like to ask the other speakers before that to share with us the things that they want to leave the audience with as the main points that they made. And I'd like to do it pretty much in the order of presentation. So, Armando, would you like to take a minute or so and offer some key takeaways for the audience?
Sure, that sounds great, Sal. Before I jump in, I just wanted to extend a thanks to the other speakers, to Sean, Deepa, and Claire. I've enjoyed listening to your segments, so thank you for your time in this. As far as key takeaways from what I discussed today, the first point I wanted to make, that I would make, is that any patent damages claimed, as we've heard a number of times today, must be based on the specific facts of the case at hand. And the other thing is that in calculating patent damages, we've heard a number of times, and I think it's a good takeaway here as well, is that apportionment is important. It's an important element in all patent cases, and it's necessary for consideration in both reasonable royalty and lost profits analysis. I would also add to that that the objective of apportionment, as we've talked about, just to drive that point home, is really to separate the value between the patented features and the non-infringing features of the accused product. And as we heard in my segment earlier today, the federal courts have found the essential requirement is that the reasonable royalty be based on the incremental value that the patented invention adds to the end product. The other point I'd make here is that there may be more than one reliable method to accomplish apportionment in a given case, depending on the facts and circumstances of that matter. We heard in Exmark that apportionment can be addressed in a variety of ways, including by careful selection of the royalty base, as well as by adjustment to the royalty rate, or a combination of the two, given the facts, again, and circumstances on the matter. In any event, the ultimate analysis has to reflect the incremental value, as I've said, and it has to apply a sound and verifiable methodology. And lastly, or the final point I'd say, is that we heard from the Federal Circuit that the Federal Circuit does not limit apportionment to specific methodologies, for the reason that flexibility is required to determine fact-dependent damages. Given different cases, given different facts, it's important to really look at what the fact pattern is for the case at hand and fashion the damages methodology appropriately to that. And with that final point, I'd say back to you, Saul, and Knowledge Group. Thank you very much.
And thank you, Armando. Let's move on to Deepa. I know you had some key takeaways. Would you like to take a minute or two to share them with us?
I would. Thanks, Sal. So I think in my section, the way I'd like to break it out, what I discussed, the first is the when. When do we use comparable licenses to apportion? So we spoke about how sometimes you do apportionment through the base, through the royalty base, through the SSPPU or beyond, and sometimes you can do it through the rate. And one of the ways you can apportion through the rate is through the hypothetical negotiation construct and running through the Georgia-Pacific factors, specifically an analysis of factors relating to evaluation of comparable licenses. So that's the when we could use this methodology to apportion. Next, I discussed how you can do it, and we said, you do it by evaluating technological and economic comparability, and you work with the technical experts to understand where technologically the hypothetical negotiation license, the litigated technology is, as opposed to the patent tech in the license you're evaluating. And then you look at economic comparability, where you look at a host of factors that have to do with the parties, their negotiating positions, their positions in the industry, their relationship between each other, the expected benefits occurring to them, and the scope of the grant, whether the license was final. So there's a host of issues which all fall under the bucket of economic comparability. And then I spoke about, I think what's interesting to a lot of people, which are examples from decisions. So we did one bucket, which was use of third-party sources. And I spoke about the Meridian case there. And then we spoke about reliance on jury verdicts and how there have been 3 recent Daubert decisions where experts' opinions have been excluded for their reliance on jury verdicts, which were not very closely tied to the case. And this is not a takeaway, but maybe a homework for my listeners. There's a very interesting recent decision, Sprint versus Time Warner. It's a Federal Circuit decision from the end of last year, and it involves, among other things, this reliance on jury verdict. And it's an example of a case where the Federal Circuit affirmed the trial and the decision on use of a jury verdict, and it's an interesting read to see how and what the rationale there was. So that's it from me. Thank you again, Sal.
And thank you, Deepa. Claire, it's your turn. You have some key takeaways you'd like to share with the audience?
Yes, thank you, Sal. So I want to start by echoing what my fellow panelists have said, which is I think if you have damages case, and it will be useful to engage damages experts early on. And I think that particularly applies to situations where you think there is a natural experiment to be used or explored for quantifying the profit that's attributable to the patented feature. And that is because, as I discussed in my segment, using this method requires knowing whether the facts of the case would support it. And it also has quite a bit of data requirement. It could either be very granular level data or macro level data. So it's useful to engage damages experts early on to explore those issues and see if this method can be used. And that's it. Thank you, Sal.
And thank you very much, Claire. Finally, Sean, I know you went over the slide, but I would like to give you the opportunity one more time if you'd like to review your key takeaways.
Sure. Yeah. Just briefly, when you're trying to figure out whether or not you need to apportion the royalty base, the first question you need to ask yourself is, well, how are you expressing this reasonable royalty? If it's a lump sum amount, or the base is a number of units that you're multiplying by a dollar value per unit, then you would not necessarily need to apportion the royalty base. Apportionment, of course, as I said before, is always necessary, but in those contexts, the royalty base apportionment doesn't necessarily apply. If your base is expressed as a dollar value and the rate is a percentage, then you have the 3 general exceptions to the rule of needing to apportion the royalty base. And the facts of the case are going to determine whether or not any of these 3 can apply, but of course they are, as I said before, the entire market value rule, using a damages model in which you're relying on comparable license agreements where the royalty base was not apportioned. Or the third option is when the scope of the asserted claims cover the entire end product. So those are sort of your 3 most common situations where you would not necessarily need to apportion the royalty base. But of course, again, apportionment will still be necessary. Thank you.